My story starts before the October 2015 mediation in July, with the addition of claims to my divorce petition against Michael J. Johnston regarding community property, a century of the company. Borer and Zucker, under the Coons-Fuller law firm, were brought into the divorce cause due to their corporate experience and financial CPA background to uncover anticipated losses from removal of assets from Centria. Cause: these claims against Johnston and Centria include shareholder oppression, potential embezzlement, and those will be included for your review and attachments. No decision has been made on these claims, and I am pursuing Mr. Johnston currently under a different cause. Following the addition of Borer and Zucker, and during the July 2015 deposition of Johnston by Zucker, about 3 months prior to the mediation of abuse, possible improper activities of both lawyers, Frankfurt and or Brady, regarding Johnston's activities and Centria and contracts, and all were revealed. See the marked arrows on the deposition. Notice how the discussions towards the end of the deposition become more intense on protections not given to Centria by these lawyers. During the same deposition, at break, Michelle Borer of Borer and Zucker told me that I had claims for dual representation and that could help with legal bills, and did I want for them to follow up on this. She seemed very excited this was uncovered, so I said yes, as I was happy to have legal expenses paid. Nothing else was told to me about this afterwards, even upon asking, as if avoiding the subject. Nothing else was said until mediation day, October 30th, 2015. And these claims discussed were denied by Bergman, with a meeting between Bergman, myself, and Zucker, stating that although Michelle Borer was energetic, she was not very smart. And I did not have claims against Brady or Frankfurt. Although I do not have a recording of this event due to the insistence of the cloak of confidentiality used to obscure abuse, the inappropriate activities that occurred during mediation should further confirm this and all claims. Of great interest is that on July 31st of that same year, Evans, my divorce lawyer, wanted to separate the divorce and corporate portion of the billings. On that same day, I signed a contract with Borer and Zucker, and I paid a $5,000 retainer for them to represent me. Also on that same day, Zucker sent an email to Borer, responding to her that I did have dual representation claims against Brady, but this time to stew on them and let Bergman handle this at mediation. By definition, stew means that Borer and Zucker had no intention of telling me about my claims. And I did not know until I filed suit on them as a pro se and received my case files did I find out this email. They even gave representation for my claims to Bergman. Why would Bergman handle my claims for dual representation when Borer already told me that I could get my legal fees paid? Why did Borer and Zucker intentionally not tell me about my claims, and were they intending on protecting Brady by giving my claims to Bergman? Borer and Zucker should have handled these claims with zealous representation, but they did not. They gave them to Bergman. A fact based on this email: did Borer and Zucker ever represent me? Or was my signing the contract and paying money a ruse to get money from me? If I was to be zealously represented, shouldn't they have actually represented me instead of Bergman? Or was their lack of representation and the issuance of my claims to Bergman nothing more than an attempt to protect Brady and possibly Frankfurt, a board member and once officer of the Houston Bar on ADR? Are lawyers assisting in shareholder oppression a crime, as what appears that Brady and Frankfurt may have done? Were these lawyers more important than upholding the justice, the court, and the law? If true, was the intentional countersuit against me by Borer and Zucker for unpaid legal fees for representing me in the cause currently in appeals nothing more than a frivolous lawsuit, since they decided on the day that I contracted with them, per email, that they gave my claims to Bergman? If Bergman had my claims, then nothing they did represented me, so why should they be paid for those activities? Maybe they should seek reimbursement from Bergman or Brady, maybe Frankfurt. Was the repetitive allowances for Brady for extension and discovery data of a century request in July, and the final intentional delay of revealing discovery for 20 days after mediation by Zucker of Borer and Zucker, who specialize in corporate law and accounting, a method to hide from me the disparities in accounting activities of Centria? They were hired to investigate and expose the activities of Johnston, who already attempted to take all assets of Centria to move into his corporation without shareholder approval. Wouldn't it have been prudent to have subpoenaed the bank records directly, records that could be not manipulated by Johnston, as Bruce Jameson did in 2016 prior to the 2016 mediation. Bohr and Zucker are seasoned corporate lawyers who acknowledged in an email that the QuickBooks data included $200,000 in uncategorized expenses, and that was odd. Yet they did nothing to seek bank records in any months from July to October to show bank records. Records that did eventually show issues when acquired by Jameson in 2016. The day prior to this 2015 mediation, Zucker accused me on the phone on a response with Johnston having nothing to do with this case, as if to justify something. I was confused and asked for a copy of answers to whatever questions that Zucker had sent to Johnston. Zucker responded that he did not send questions, which seemed very odd.